Good morning, everyone, and welcome to this Institute for Government event. It's a launch for our new report, which we published last week, which is entitled Legislating by Consent, How to Revive the Sewel Convention. And if you haven't had a chance to look at it yet, it's available on our website. And I want to thank the Joseph Rowntree Reform Trust, who have sponsored both the report and the event today. So thanks very much to them. A little bit about the report before we kick off. It covers really the history, the constitutional function and the practical benefits of the Sewel Convention. And as many of you will know, that's the convention under which Westminster doesn't normally legislate in devolved areas without consent from the devolved legislatures that are affected by that legislation. And the report makes the argument that having served as a pillar of the Westminster devolved relationship for the last 2 decades, the Sewel Convention has been placed under serious strain, first by Brexit and now most recently by the UK Internal Market Bill, for which we think consent is unlikely to be given by any of the devolved legislatures. The report sets out 8 recommendations for reform of the legislative consent process, and these are designed to revive and strengthen the Sewel Convention and to improve how the UK government and Parliament deal with devolution issues and engage with their devolved counterparts. So how are we going to run the event today? We're going to kick off with Akash Pown, who's one of our senior fellows at the Institute of Government and one of the authors of the report. He's going to take us through its main conclusions and recommendations in a little bit more detail. Then we have a great panel who are going to give us their thoughts and responses to the report. We'll begin with Karen Bradley MP, then we'll move on to Pete Wishart, and then we're lucky enough to have Mick Anthony, who's a member of the Welsh Senate, and I'll tell you a little bit more about them in a minute. Once we've had their responses from the panel, then we'll move into Q&A, but you don't need to wait until all that has happened before you start submitting your questions which you'd like answered by the panel or Akash in the using the Q&A function in Teams. And if you're tweeting about the event, which we're very happy for you to do, please use the hashtag IFGDevo. So a few words about our panel before we move on. Karen Bradley is the MP for Staffordshire Moorland, has been since 2010. She is, of course, a former Secretary of State for Northern Ireland and has been the chair of the House of Commons Procedure Committee since January 2020. Pete Wishart MP is the longest serving SNP MP and represents Perth and North Perthshire and has done since 2001. And he's currently the SNP's shadow spokesperson for the Cabinet Office and the Constitution and has been chair of the House of Commons Scottish Affairs Committee since 2015. Mick Anthony is a member of the Welsh Senate and he has been the Welsh Labour and Cooperative Senate member for Pontypridd since 2011 and is currently chair of the Assembly's Legislation, Justice and Constitution Committee. The committee considers legislative consent memorandums as well as any other matters relating to justice and the Constitution. And Akash Pown, who is going to speak first, is a senior fellow at the IFG. He leads our devolution team and has worked at the IFG for over a decade. The Devo team are currently looking at a number of different devolution related issues, including how the devolved institutions are funded, how the UK and devolved governments have worked together during the coronavirus pandemic, and we're planning future work looking at the performance of public services across the UK, the future of the Union, and where next for devolution within England. So I think Akash is going to be busy. But I'm going to turn to him first now to just give us a bit of an introduction to the report and its main conclusions and recommendations. Akash.
Thank you, Hannah. Good morning. Welcome, everyone. Thank you all for joining. Thanks especially to our panel who Hannah has just introduced. And I really look forward to hearing the comments from each of the 3 of them in a few moments. Special thanks also due to my co-author Kelly Shuttleworth. Hello, Kelly, who's watching and live tweeting this event at the moment for the Institute for Government Twitter account. So Hannah has already given some background to background about the project and the report, including the definition of the Sewel Convention. So I won't repeat that. And as she also mentioned, and as we discuss in detail in our paper, the Sewel Convention quite quickly, actually, after 1999, became a central part of the UK territorial constitution and devolution arrangements, and indeed it has even deeper historical roots than that. It goes back to the way that Westminster engaged with the old Northern Ireland Parliament in the previous era of devolution. Consent in the 2 and a bit decades since 1999 has been given for over 200 acts of parliament. There have been up to now, I think the figure's around 400 consent motions in total across the 3 devolved legislatures, and disputes over consent have been on the whole rare. Prior to Brexit, and we'll certainly come back to that caveat, the Scottish Parliament and Northern Ireland Assembly had each refused consent for a UK bill on just one occasion each, and in both cases the issue was then swiftly resolved by means of amendments to the legislation passed at Westminster. There have been a few more disagreements in the case of Wales, often because of the greater degree of uncertainty in the Welsh devolution settlement about precisely where the line lies between what is and what is not devolved, and therefore whether or not consent is required. But overall, the consent process has worked smoothly, and it has delivered a number of benefits to all sides. So first and very importantly, it's protected the political autonomy of the devolved nations and of the devolved institutions within their spheres of competence, albeit within a wider constitutional framework that preserves parliamentary sovereignty. Sewel has also encouraged and facilitated cooperation between the governments, because the need to secure consent means that government departments in Whitehall have the incentive to engage early on in the policy process to try to reach agreement and avoid disputes later on, and it's mostly worked well in that respect. It also helps provide for consistency of law across the UK in many areas where that's favoured by all sides, including sometimes, for instance, to ensure consistent implementation of international commitments. And it allows for swift nationwide action in times of crisis, and a good example of that would be the passage with consent of the Coronavirus Act earlier this year. But Brexit has placed the Sewel Convention under serious strain. We've seen the passage by the UK Parliament of 2 key pieces of Brexit legislation in 2018 and again at the start of this year without the consent of at least one of the devolved legislatures. And as mentioned, a big battle is now underway on the UK Internal Market Bill, which was drafted with little, if any, devolved input by all accounts, despite its very significant impact on the devolved institutions. As things stand, consent to the bill is unlikely to be forthcoming, and I'm sure we'll hear more about that issue over the coming 50 minutes or so. Consent is also yet to be granted for a number of other Brexit-related bills, including on trade and immigration, the environment and agriculture, although in some of those cases the disagreements are not so severe. But nonetheless, if agreement is not reached on any of those bills, then the UK Parliament will have to decide whether or not to press ahead without consent. And to do so, again, we argue in the paper, would have potentially serious consequences for UK devolved relations, for the stability of devolution and potentially the union itself. And so in that context, we have published our paper that sets out 8 recommendations for reform. They are, of course, detailed in full in the report, and I do hope people take the time to read it. But just in brief, we have recommended the following. First, we think the UK government should formally accept that the Sewel Convention applies in the exact same way to legislation that amends the powers of the devolved bodies, which the UK Internal Market Bill does, as it does to legislation in already devolved areas. And that might sound like a bit of a technical point, but without that guarantee, the concern at the devolved level is that Westminster might legislate to take powers back unilaterally to Westminster. So it is a very important issue. Second, we think the UK and devolved governments should reach agreement on what are the limited set of circumstances in which it may be legitimate for legislation in devolved areas to be passed without consent. The Sewel Convention refers to what should happen normally, and it should be in only exceptional circumstances that it is disregarded, but in certain crises and so on, that there would be a case for legislation without consent. But it should not be for the UK government to unilaterally state, perhaps when it becomes apparent that consent is not forthcoming, that, oh, well, the circumstances are exceptional, we're going to have to proceed regardless. Third, importantly, the government should not introduce into Parliament any bill where Sewel applies if that bill has not been shared in advance, ideally an agreed period of a few weeks, with the devolved governments. And again, that is what happens when the process is working well, but it has not happened on a few of the cases already mentioned. Then, coming forward to the legislative process itself. When a bill is introduced into Parliament, our fourth recommendation, we suggest the government should lay alongside it a devolution statement that sets out whether and why consent is needed, whether it is expected, and how the devolved governments have been involved in the process of drafting the legislation. And then if there's disputes unresolved at that point, what their plan is to try and resolve those. And this would help to improve accountability of the process. Fifth, then, a committee of the UK Parliament should scrutinise this devolution statement and consider the wider set of devolution and consent issues, taking evidence if necessary from both UK and devolved administrations, and then report to Parliament on the state of play. Sixth, relatedly, if there is disagreement over whether a bill does relate to devolved matters and therefore whether consent should be sought, the committee should seek independent legal advice on this issue and incorporate that in its report to Parliament. And again, the point is that it is not legitimate in our view for the UK government simply to declare, based on our unpublished analysis, we don't need to seek consent for this issue, so we're going to just proceed without going through the consent process. And there's no way for the devolved administrations to challenge that, and that has happened on a few occasions. Seventh, then, if ultimately, and as we say, this should be in exceptional circumstances, the government does wish to proceed at the end of the legislative process without consent, then a minister should make a statement to each House of Parliament setting out in detail the reasons why they've reached that conclusion, and then each House should consider that issue and vote on a motion of whether to proceed or not with the bill. And that's to ensure that this cannot happen surreptitiously, and if Westminster is going to take this decision to disregard the consent requirement, it does so openly and is held to account and holds the government to account for that course of action. Finally, eighth, we suggest that there should be fuller public information provided about the consent status of all bills before Parliament in order to make clearer what is currently not clear, the connection between the consent process at the devolved level and the legislative process in Westminster. So that's our suite of recommendations. They are intended to, as mentioned, improve transparency, to sharpen accountability, and to strengthen intergovernmental and interparliamentary relations. They're not the only ways to achieve those objectives, and I'm very interested now to hear thoughts on those ideas and alternatives as well. But I do believe that they would mark an improvement on current practice. There are also more radical approaches that one could take. something more like a legally enforceable consent requirement, or even a federal constitution, and there might be a case for debate about those matters. But our approach has been very much to set out proposals that we think could be implemented within the current constitutional framework, at least if there is sufficient political will and a genuine desire to repair the UK devolved relationship, and that's an important caveat. So I will stop there. Thank you all for listening, and I very much look forward to the thoughts of the other panelists.
Thanks very much, Akash. And indeed, some of the points you were flagging at the end there have already come up on the Q&A, so I'm sure we'll be getting into those questions later. But can we turn now to Karen? You're obviously chair of the Commons Procedure Committee. What's your view on these proposals, and indeed on the current state of House of Commons procedures and how they deal with devolution?
Thank you, Hannah, and thank you, Akash. That was a very interesting and informative introduction into what is a detailed and very thoughtful report. I suppose I have a slightly unique perspective on this, because as well as being chair of the House of Commons Procedure Committee, which is the committee that looks at how Commons business, public business, is conducted and whether it can be, our procedures can be improved. I was also, as you've already referred to, the Secretary of State for Northern Ireland. So I have had the experience of sitting through devolved settlement type arrangements. For example, the JMC, which is a interministerial forum that meets, probably should meet more regularly than it does. And I can't say how often it's meeting at the moment, but I would have said that actually you probably can't have too many JMCs, though those that take part in it might disagree at times. But it is really important that we do have as much communication and discussion between the devolved legislatures as is possible. Now, of course, when I was Northern Ireland Secretary, it was a time when we didn't have any devolved governments in Northern Ireland. So I had a slightly different take on it than my other territorial office counterparts, because the Sewel Convention didn't come into play in terms of the work that we were doing as to whether we were looking to get legislative consent from Northern Ireland. Now, with my procedure committee hat on, it's clear to me that there are issues that need to be looked at. And I think, you know, you've talked about Sewel and when it was encapsulated back in the late 90s when the devolution settlements were written. I suppose there's a couple of differences from then to today. And you're right to say, of course, Akash, that Sewel was an unwritten and unspoken convention between Westminster and the Northern Ireland legislature up to 1972. When obviously direct rule was reintroduced in Northern Ireland, but there was devolved government in Northern Ireland between 1922 and 1972, and Sewel effectively operated at that time. It just wasn't spoken about. But when Sewel was first encapsulated, when the devolution settlements were being developed, there were two differences. The first was that actually there wasn't that much political difference between the devolved legislatures across the United Kingdom, that actually the government in Westminster was of a similar political hue to the governments in Cardiff and Edinburgh, certainly. And the other difference was that we were a member of the EU. So much of the devolution settlement revolved around matters, or involved matters, which were competences of the EU. And therefore, a lot of stuff that we're now going through at the moment through Brexit just simply didn't need to be written. It didn't need to be codified. It didn't need to be discussed because those matters were actually the remit of Brussels, not the remit of Westminster or Holyrood or Cardiff or Stormont. And so this means that everything has been brought to the fore at this current time. And you talked about the current Internal Markets Bill. That is the bill that will probably see the biggest challenge to Sewel that we've seen for some time because of the differences of opinion across the four legislatures. It was put to me that, you know, we used to talk about fixing the roof while the sun shines. Well, we're trying to fix the roof now while there's a massive thunderstorm going on, and that's quite a difficult thing. But I think there's some great points that the IFG have made. You asked a direct question, Hannah, about how does the House of Commons procedures tackle this? And that's a really important question, and one that we've been questioning on the procedure committee, and that's why I'm pleased to announce you get the exclusive announcement that actually we agreed yesterday that we will conduct an inquiry into how the devolved settlements work and how Sewel operates today in this new constitutional arrangement for the United Kingdom. And we'll certainly be looking at some of the at all the points that the IFG have put forward and more, I'm sure. But I think I'm particularly interested, some points there that I thought were really interesting. The idea of common agreement, which could take some of the sting out of Sewel. It could make it much easier if there is a common agreement over those areas where Parliament would normally consent, a sort of reverse Sewel, I suppose, is a really interesting idea, and one that I think we will want to look at in more detail. I do concur with the conclusion you reach about not putting Sewel on a statutory footing. I think that we have seen how the different legal systems across the United Kingdom can have different interpretations of matters that the UK Parliament or other parliaments might legislate for, and putting it on a statutory footing. I think this is not the time for that. If ever there is going to be a time, this is not it. And I guess the final point I'll just make is that we're looking at Sewel now, and we're all interested in it because there's matters of conflict. There is debate, there's discussion. But you're right, you've pointed out that Sewel can work really well without anybody really noticing when there is harmony. And the coronavirus regulations definitely is an area where you could stand up and say Sewel has worked really well, and the right level of communication, the right level of discussion means you can get really difficult legislation on the statute book across the UK in a harmonious way. Now, there may be some debates that might be had in the House of Commons over the next few weeks about whether there's been enough scrutiny of that legislation, certainly in Westminster, but I think no one could disagree that Sewel has worked in a seamless way, and none of us have been talking about it on the actual regulations themselves. So with that, I'm looking forward to hearing what the other panelists have to say. And as I say, we've started our inquiry, we've opened the inquiry, and we'll be asking for evidence. And I hope that the IFG and many of the people listening to this event will be able to give us some contributions. Thank you.
Thank you very much, Karen. And now we're going to move on to Mick Anthony, who is, as I said, chair of the Welsh Parliament's Legislation, Constitution and Justice Committee. Mick, we've heard the sort of view from Westminster and from the people in Westminster who are, like Karen, reflecting on how Sewel's working. What's the perspective like from the Welsh Senate?
Well, I think it's very different, and I think it has to be, the debate has to be put within the history and the concept of devolution. I mean, I think it is very difficult to talk about Sewel without putting it in the context of how devolution has developed and been implemented since Kilbrandon report back in '74. And I mentioned Kilbrandon because I suppose if we've taken on board the crucial recommendations in respect of devolution for England, the discussions we're now having might have been very, very different. I mean, Lord Kilbrandon then recognised that changing one part of the UK constitution for Wales and Scotland did have very significant consequences for England, which had to be addressed and which have still not been addressed. And in my view, this goes to the nub of our emerging constitutional crisis. And I think there is a crisis. I don't think there's much disagreement that the UK constitution has become dysfunctional. It is a consequence of decades of dereliction and attention to it. Just turning to the Joint Ministerial Council, that was set up to provide a mechanism for the four nations to engage and cooperate in areas of common interest. It's not fit for purpose, and calls on the UK government for reform have failed. The Interparliamentary Forum on Brexit, which I think is one of the more positive parliamentary developments in recent years, representing the various constitutional and legislative parliamentary committees across the four nations, has consistently described it as not fit for purpose, and the failure to reform this and to deal with this, I think, has been a major dereliction of responsibility. I think also the impact of the COVID pandemic has in some ways exposed the constitutional weaknesses, because our potential strengths, it has highlighted in some ways. It has led to the development of four-nation government and engagement. However, that engagement has often been inconsistent, fragile and dysfunctional, and this impacts on Sewel. I have to say, often UK ministers have struggled to understand the importance of mutual engagement and indeed the role of devolved governments, and often not even understood when they've been acting in their capacity as UK ministers or when they've been in fact acting as ministers for England. And I think this again is part of the problem, defining the role of the UK Parliament within this, acting as a parliament for the whole of the UK, but also as a de facto parliament for England. I think I also have to turn slightly to the role of Brexit in all this, because in April 2018, and some of this impacts on what Karen has just said, the Welsh and the UK government reached an intergovernmental agreement on the EU withdrawal bill and for the establishment of common frameworks. And it was on this basis that we gave consent by the Welsh Assembly, now the Senedd, to the EU withdrawal bill. Now, discussions on common frameworks and on legislation have been difficult, but they were well underway. The problem we now face, and it's why the report is a really good report, I just think is being overtaken by events, is the internal market bill, which drives a coach and horses, not only through the JMC, through the intergovernmental agreement, but also undermines the cooperation which had been taking place on the development of common frameworks. And in my view, it threatens to destabilise the UK still further and at the worst possible time. I think that is very politically damaging and irresponsible. If the bill is not substantially reformed or dropped, I think it will be the final nail in the coffin of the Sewel Convention and lead to increased fragmentation of the UK and increased political polarisation. My committee's unanimous view, and we are a cross-party committee, is that the internal market bill undermines devolution and recentralises power in the UK government. Now, after the UK government overrode the Scottish and Welsh government's refusal of consent to the EU withdrawal agreement bill, Sewel, at the very best, in my view, has been in intensive care. The internal market bill effectively switches off its life support, and in the present form, I can tell you that I cannot see that consent will be given to the bill. We were told after the overriding of Wales and Scotland in the withdrawal agreement bill that Sewel was only breached in specific, singular and exceptional circumstances. And I think there is the nub of the problem. Who decides? The UK government, acting as the government of the UK, and in other circumstances as the government of England. It writes the rules, then acts as judge and jury in all these matters. So in my view, the only way Sewel Convention can survive is for there to be a dispute resolution procedure and for it to be justiciable. So I welcome the report, but I believe it is too late for the reforms, any reform that does not include dispute resolution and justiciability. Our First Minister said in the beginning of January that this was now the convention was now a constitutional flashpoint. He said the Sewel provides an arbitrary and unilateral power to the UK government to override the refusal of a devolved legislature to give consent without explanation and without accountability to either House of Parliament and the exercise of power. That is partly dealt with by the report, but I think the internal market bill drives a coach and horses through that and threatens really the stability of the UK. Thank you.
Thank you, Mick. Pete, you obviously have another perspective again, both as chair of the House of Commons Scottish Affairs Committee, but also as a SNP member of Parliament, the Scottish perspective. What's your view on these matters?
Can I first of all thank you for the very kind invitation to appear this morning. It's been fascinating following this debate, and can I thank you, the Institute of Government, for what is, I think, it's a fantastic document, which is a tour de force of the history and operation of the Sewel Convention, and I think it's a very worthwhile contribution to the debate. And it's always difficult when you follow somebody who almost says exactly what you're going to say in advance, and I think Mick has adequately and perfectly described some of the issues that we have in the devolved administrations when it comes to the Sewel Conventions. I mean, there's no issue with either Wales or Scotland with the 8 recommendations that's been made. We would probably adopt them tomorrow. There's no issue with that at all. The problem is with the UK government, and I'm just wondering what sort of appetite a UK government now have for this type of reform, particularly when, for them now, particularly during the Brexit process, it's all about asserting parliamentary sovereignty. That's what it was all about. And I think to them that Sewel isn't just so much like something that's got to be reformed and improved and developed. It's an irritant to them now. It's something that's got to be overridden and it's got to be overruled and accommodated. They won their Brexit battles on the basis of their view of parliamentary sovereignty, and I think they want to aggressively assert that just now. And what that means is actually aggressively challenging some of the issues around devolution. And we've seen that in the EU Brexit legislation, and we're particularly seeing it in spades when it comes to the internal market bill. Now, I think everybody who's watching this would accept that there's no secret that relationships in the UK just now across the devolved administrations are broken almost beyond repair. The intergovernmental relations are now characterised by mistrust and a total lack of respect. And in the last few years, I would only describe the way that the UK government has approached devolution as a sort of aggressive unionism designed to curb the powers of the devolved legislatures and neutralise any challenge that they might present to their greater Brexit project. Now, we talked about the internal market bill. I mean, I think again, it's not going to be any secret, but there is no way that a legislative consent motion will ever be granted in something like this in Scotland. And our job is to defend and protect the devolution settlement and ensure that our Scottish democracy is upheld. And what we observe in the internal market bill is a direct challenge to these issues in Scotland. And I think it's also fair to say that the intergovernment infrastructure which has underpinned devolution is in tatters, and it's difficult to see how it's going to be put back together again. I know that Akash gave very valuable evidence to the Scottish Affairs Committee when we looked at intergovernmental relations across the United Kingdom, and what we observed is it's just not fit for purpose. And when we get to the Sewel Convention, it's a critical principle that's underpinned every facet of devolution, and it's in effect made inter-parliamentary relations work. But it has to be said, it's barely worth the vellum. It's not even been written on. I think Sewel is if this was adopted, it could be the basis of a start of making sure that we could get back into a much more level keel when it comes to this. But I just do not think that this is going to happen. There maybe was a golden age of Sewel when there was good relations across all the UK with governments that had pretty much the same views on the constitution. But that just doesn't work when we have different governments pursuing different priorities with competing political objectives, and I don't think Sewel can hold the line. And something has to give when you have these situations, and that's something I believe has been Sewel. I think for us, as long as we're in the UK, we'll make every attempt to try and design an effective means to manage devolution and try and improve the way that we engage and look at the apparatus that support intergovernmental relations. But I think also in Scotland, we have to observe that the constitutional middle ground has now more or less disappeared. There's now a clear dividing line between an independence movement that's clearly on the rise, confident, assertive, quickly becoming the new settled will of the Scottish people, and an aggressive unionism that wants to assert Westminster sovereignty, that has to undermine devolution institutions if it's got to prevail. We're getting to the stage, I think, that devolution is almost lost. If managed and sustained properly, and the Sewel Convention helped to do that, it could just about have brought a permanence to the UK's constitutional arrangements. But I think for most of us in Scotland just now, particularly when we observe opinion polls, that the days of, you know, the high watermark of devolution with its weird UK symmetry is more or less starting to dissipate and disappear. And the failure of devolution with all its apparatus has left the door open to the independence era that we're just about to enter into just now. I think I'll just end by saying I think that the devolution years are pretty much coming to an end. Welcome to the independence years.
Thank you very much, Pete. Karen, I'm gonna kick off now with some of the questions we've been receiving in from the audience. Thank you everyone for sending in your questions. Obviously, Karen, you're not a spokesman for the government, but you're our panelist with a sort of Westminster perspective here. Both Pete and Mick have raised the question of, you know, whether there is any political will to do the sorts of things that we're proposing, or indeed anything else, to strengthen the current devolution settlement. What's your view on that from Westminster?
Well, I think that within Parliament there is a political will to do it. I can't speak for the government. I'm not a member of the government and I'm not privy to the discussions that happen, but certainly there is a real desire to deal with these things. And I'd say that's why the committee was keen to look at this. The committee, just like Mick's committee in Cardiff, is a cross-party committee. It includes MPs that are members of Pete's party as well. So it really does cover all parts of Westminster, and we were keen unanimously to look at this and try and see how we could resolve some of these questions. I mean, my committee in its previous incarnation last looked at this over 20 years ago, and as I say, there was a very different political and constitutional situation. We didn't have Brexit, and we had harmony for across the legislatures in terms of political leaning. So there is a will amongst parliamentarians, and we will do all we can on the procedure committee. What I can't tell you definitively is whether there's a will within government, and it wouldn't be right for me to speculate on that.
I think that's entirely fair, but I'm just going to push you a little bit further. I mean, what do you think would make it in the government's interests to pay serious attention to this question?
Well, I think that the Internal Markets Bill has brought it to the fore, and I think that whilst an 80-seat majority in the House of Commons makes it easy enough for the government to get difficult legislation through, and I say that as somebody who hasn't necessarily voted for the legislation myself, but the House of Lords is going to be a very different animal, and a lack of legislative consent motions from 3 devolved legislatures could be very persuasive to the House of Lords in terms of the way that they decide to vote on this. And, you know, normally what would happen is there would be negotiation, there would be discussion, there would be an attempt to compromise. Mick's referred to the agreement that happened on the Withdrawal Act itself, the intergovernmental agreement between Wales and London, Cardiff and London, that meant that there was a legislative consent motion from Cardiff that did persuade the Lords at that time to give the Withdrawal Act its 3rd reading. We're in a different situation. We've got a very controversial bill that is not supported by, including a large number of the government's own members of the House of Lords, and I think this might bring it to the fore.
Thank you, Karen. Mick raised the question of putting Sewel on some kind of either a statutory or justiciable sort of standing. Akash, can I just come back to you? I mean, you obviously thought in the course of putting together your recommendations about all the different options for Sewel. What do you think would be the implications of putting Sewel into statute or making it justiciable?
Well, I mean, there's different ways you can put it into statute, and I mean, many people will be aware, but there is a very limited statutory footing already to the Sewel Convention, albeit that the Supreme Court has made clear that it has no legal effect at all. But in the Scotland and Wales devolution legislation, the Sewel Convention is recognised as a convention that should normally apply. But yes, it's a non-justiciable section of that legislation. So what else could you do? I mean, we've said in the report that some of the recommendations we made could be put into statute. So there could be, for instance, legal requirements potentially to have a better process of consultation, perhaps with the devolved administrations, to layer the devolution statement I talked about alongside a bill. Those sort of procedural elements perhaps could be put into statute. That is, I mean, and on those we kind of were open-minded. You could also do that through a memorandum of understanding, and there might be that would probably be the initial way one would try to go. Though yes, in the end it depends on there being willingness on all sides to reach that agreement. If you were to go further, and I think the kind of reforms that certainly Mick would favour, and the Scottish government have made those recommendations as well. In principle, yes, you could make Sewel into a legally binding consent requirement. You could essentially qualify or constrain parliamentary sovereignty, and say that if consent has not been given to a bill that where the conditions of Sewel are obviously invoked, that, well, presumably you could say that the courts could disapply that legislation or something along those lines. But I think, I mean, the conclusion we reached was that really starts to open up a far bigger set of questions about the nature of sovereignty, about the relationship between Parliament and the courts, about the governance of England as well, like what's England's place within a constitution that starts to become more like a federation. And those are all really big and important questions that were kind of beyond the scope of our report. And as I said, I mean, what we've tried to do is to take as a given that our current constitutional framework, including parliamentary sovereignty, is here at least for the short term, and probably for the medium term at least. Given that, what could you do to improve things? And alongside trying to improve the system along the way we've suggested, by all means, let's have that wider debate. But I think, yeah, as I say, we've slightly worked within the bounds of political reality, because we're actually quite keen to improve how things operate in the here and now.
Thanks, Akash. And I should have said that was a question from Andrew Potts. We've got another question from an anonymous viewer which just builds on that. And this is a question, I think, for Pete and for Mick, saying the Sewel Convention, as it stands, is partly designed to uphold the sovereignty of the UK Parliament. And so, if, as you suggest, it were possible to make the Sewel Convention more binding, would that have implications for the sovereignty of the UK Parliament, and then we would end up in a sort of stalemate on the most politically contentious issues?
Well, so this is the big issue, isn't it? You know, I mean, this is a more assertive UK Parliament that's just renewed its whole idea of parliamentary sovereignty through its Brexit battle. It was all about taking back control, and taking back control doesn't mean control to Edinburgh or Cardiff. I mean, let's be clear about this. It's control for Westminster. And it sits very uneasily with this idea of Scottish and Welsh democracy, where, you know, we have a vested interest in ensuring that the devolution settlement and the powers that are our responsibility are upheld and maintained. So you've got this inevitable tension just now. And I just don't see any appetite whatsoever. In fact, the exact opposite, for an accommodation across the United Kingdom which respects that within Scotland and Wales. Now, they'll talk about respecting it, but they never do. I mean, one of the things in the Internal Markets Bill, for example, means that for the first time ever in the whole history of devolution, the UK government can directly invest its own priorities in what are the devolved areas and responsibilities in Scotland, because what the UK has actually done is assumed the powers of the EU when it's come to structural funding and spending. And the thing that they have accepted this equivalence of UK rule across the United Kingdom with the EU, and they're so different. I could go into 100 reasons why the UK is different to the EU. And let me be absolutely clear, from Scotland, we would accept the authority of the EU any day before the authority of the United Kingdom when it comes to these. So you've got these inevitable tensions just now, which, like, I wish Karen all the best in her inquiry, and I'm very much looking forward to its conclusions and recommendations. But the battle you've got is just so overwhelming. I mean, there is nothing that the Institute for Government are recommending today that we couldn't agree in the next 10 minutes. I mean, we want to do this. We want to try and ensure that there's better. Well, we're still part of the UK, that devolution works better. But you're not going to get the UK government to agree to this. There's just no way on earth they do it. This is a UK government that's on a completely different trajectory, where the assertion of their parliamentary sovereignty is everything to it. So I just really see how it can work. And unless you get a completely different mindset from the UK government, which there is no indication whatsoever that they're even thinking about.
Mick, did you want to come back on that one?
Yeah, no, I did, and I think Akash and Peter hit really the nub of the issue. To what extent we have moved on, as Peter says, from devolution. We've actually moved during COVID to a much closer system of four-nation government, and it's quite amazing how that could actually, on many occasions, actually work very effectively. Now, Akash talked about not perhaps going so far as tackling with the issue of sovereignty, but to be honest, that is the nub of the matter now, that unless we move to this issue of shared sovereignty as opposed to the sovereignty of the UK Parliament, we really can't resolve these. And unless subsidiarity is really at the core of this, there is really nowhere to go, because you take an internal market bill that effectively, it doesn't matter how you reform Sewel, you have an internal market bill that enables the UK government, and almost without any scrutiny from Westminster or any of the devolved nations anyway, to day by day overrule and override the devolution settlement. It actually drives a coach and horses, as I said, through that. I'll just give you one example. We have a restriction on genetically modified foods within Wales. If the UK government does a trade deal that allows genetically modified food from wherever, well, it overrides us. It overrides us in so many environmental areas, in food standard areas, and it almost says, well, then what is the purpose of having devolved government if in all these areas I can stand for an election, I can stand on a manifesto, I will not know from one day to the next to what extent I will ever be able to implement that. And that goes to the nub of it. So until there is some clear delineation of powers, a mechanism for resolving disputes, and a mechanism for actually enforcing that. Because I have to say, basing the whole of this on trust, that might have been possible a few years ago. We've moved into a far more sophisticated constitutional relationship, and it has to be far more effectively defined within the structures of post-devolution government.
Just building on what you're saying there, Mick, about the internal market bill, do you think it's inevitable now that that there won't be consent, or do you think there's any way in which the bill could be amended which would enable the Welsh Senate, from your perspective, to give consent to it?
Well, listen, it would have to be very, very substantially reformed, almost to such an extent that you actually remove the bill. Because the crux of it is that this bill wasn't necessary. The whole process between the four nations was going to be about the establishment of mutual common frameworks and agreements. And it was a decision by the UK government to totally override that. That is what's understandable. The fact that Welsh government didn't actually see the bill until 2 days before it was actually presented, I think is an indication of that. So the answer is, I find it very difficult to see. We will, listen, Labour will certainly work to reform it, to take all those bits out, to minimise the damage it has. But I have to say that I would prefer the bill to go completely. But if it could be reformed, well, there may still be an unsatisfactory situation that still doesn't resolve the constitutional crisis that we actually have. And these broader issues of sovereignty and subsidiarity, unless they are dealt with, are a flat constitutional flashpoint, as the Welsh First Minister said.
Can I just say very briefly, I mean, that is totally the view from Scotland. Everything that Mick says here. In fact, it's probably worse than that we see the internal market bill as a direct assault on our Scottish democracy and the powers of the Scottish Parliament. That's as bad as it is. And there is just no way that we could see how this could be reformed. And it really has to be withdrawn if they're serious about respecting devolution.
There are 2 points to that, so I just got to come in. One is either that the bill is just a mistaken sort of negligence in approach, or it is deliberate. I have to say the view I increasingly come to is that it is deliberate, and it is a deliberate political intention of UK government. And if that is correct, it really even undermines the concept of any reform based on trust.
Karen, if consent is not given to the internal market bill, how do you think the UK Parliament ought to respond?
Well, I think that, as I've said already, the House of Commons, with the majority of the government will, I suspect, vote with the government, and the bill will go to the Lords. It's the Lords where it's going to be interesting. And without the support of all of the members of the House of Lords that sit on the government benches, which is clearly the position at the moment, and it might be that that position is due to different reasons than the reasons why Mick and Pete are exercised by the bill, but they are still valid reasons. It's unlikely that legislative consent motion not coming from the 3 devolved legislatures will persuade the crossbenchers, which are the key here. So the government needs the crossbenchers and a majority of its own members to walk through the division lobby to get the bill through and to give it a 3rd reading. And I think that's where the argument's going to be. That's where the battle lines will be drawn. It's going to be those crossbenchers and how they react to this and how persuasive that lack of legislative consent motion is to them. And that's where I think we should all, that's where the interest is going to be for the constitutional, those interested in the constitution, is going to be how the House of Lords react, and whether actually that then leads to the government using that as an opportunity to do something radical to the House of Lords will be another interesting question for us to see what happens. But I think that's where we should focus. I think that the arguments in the House of Commons are probably not where the interest lies. It's in the Lords we should be looking at.
But then what will happen, of course, is that the Lords will ask the Commons to think again, and I'm interested in what happens at that point. I mean,
well, not necessarily. If the Lords decline 3rd reading, then the Commons can't think again.
That will be an interesting situation. Mick, you wanted to come in?
Yeah, can I just say, isn't it absolutely incredible that the whole future of the union, the relationship between the 4 nations, is potentially under threat and going to be determined by a group of unelected peers? I mean, this is just not the way for nations to get together and to resolve their mutual interests. And that's why I say this whole bill is an absolute disaster waiting to happen.
I'm going to put my foot down and say we're not going to get into House of Lords reform this morning, as well as Sewel and devolution. But thank you. I don't disagree. It's another anonymous question in the Q&A saying, what do we think of the fact, what should we make of the fact that the Sewel Convention is expressed as being between legislatures, but is essentially managed between governments? And I think that's probably an interesting question for you to explore in your inquiry, Karen, but I wondered if any of you had thoughts on that. All of you, between you, got experience of different parts of the process. Karen?
I think that's a really important point. I mean, one of the things that I personally am not a fan of is English votes for English laws. That was a decision by a government to do something in response to demands from English voters to see some sort of recognition of English laws should be decided by English MPs. But it wasn't a Parliament was asking for that. That was the government brought that in, and you're absolutely right. And this is always, actually, with so much that we're doing, the procedures of the House of Commons at the moment, you might have seen there was a bit of a debate last night around whether we should return to remote voting or stick with proxy voting. I think the majority of the House of Commons probably wants to go to remote voting and vote from its phone because it's more efficient and effective. Not about not being in Parliament, it's about having a safe and effective way of voting. But the government brings forward the legislation the motions because the government controls the order paper. Now, actually, constitutionally, the government controlling the order paper is a really important thing. If the government doesn't control it, then actually, you're putting power in the hands of people who are not the executive, be it the Speaker or a House Business Committee or something else. So I think there are good reasons why the government controls that, but the government controlling the order paper, the government controlling and the executives controlling the relationships between the devolved nations does make for that interesting contrast. And I think you're absolutely right, Hannah. This is one of those points that, as the committee, we would love to hear evidence on. We'd love to hear people's views on it, and really do want to get into whether there is something that needs to change now to reflect this new constitutional settlement of the United Kingdom outside the EU.
Mick, I can see you with your hand up.
Yeah, I mean, it is an interesting question. I think it's more an interesting question for Westminster rather than Wales and Scotland, Northern Ireland. Certainly Wales and Scotland I know very well, where there is a very close relationship and working between the assemblies and parliaments and the governments. It is really more a problem for a UK parliament that has an clarity about its own role, whether it is acting as government, as a UK legislature, or whether it's acting as an English legislature. And that is that area that really has to be resolved. It does take us into deeper constitutional questions, but it is, the fly in the ointment.
And indeed, we've got another question from an, again, anonymous viewer saying, can Sewel ever be fully entrenched when there is no devolution and a separate voice or voices in England?
I think that's the key question. And there's, when we get around the table in any of the intergovernmental infrastructure, we've got the UK, who are effectively set up the rules, put together all the institutions, are there representing the whole of the UK and also representing England. And it's just such an imbalance to the power arrangements and relationships across the United Kingdom when you have that disproportionate amount of influence and authority when it comes to these meetings. And we know that there's no appetite for any regional assemblies across England. And people talk about federalism, and I know that it's Labour's view in Scotland that a federal solution will somehow resolve all these difficulties and problems, but that'll only begin if we ever get any sort of sense that there will be a federal arrangement put across England. Now, we could have federalism with the nations of the United Kingdom, but then you've got a situation where England accounts for something like over 9/10 of the whole population of the UK and how that would work. But something's going to have to be done about this, and this gets to the crux of all the difficulties that we have about the UK assuming the responsibilities for the whole of the United Kingdom of Great Britain and Northern Ireland, but also all the responsibilities for England. And I'm afraid that nearly every single issue when we look at intergovernment relations falls at that particular hurdle and test.
Mick, did you want to come back in on that?
To say that I totally agree with Peter. It is the issue that we've consistently raised. We understand it very well in Wales and Scotland, because we almost have to live with this day by day. I don't particularly agree with Peter, because I think the idea of regional assemblies I just don't think the devolution debate in England has ever been in any way strategically developed, and until that happens, it'd be difficult to see what progress there is. But there is devolution in England in some extent. You have more powerful mayors. You have the London Authority. Let's take London, where half the wealth of the UK is based in around the southeast of England. Addressing that has got to take place, because I think Sewel and I think the whole process of decentralisation of power, which for me is what devolution is ultimately about, can't take place in any realistic way until the English question is dealt with and resolved.
And on the note, we have to draw this to a close very soon, but I just want to put David Gow's question in to all of you, and he asks, do we need to go beyond Sewel and thinking about intergovernmental relations and so on, and seriously consider having a constitutional convention at this point? A very quick response from each of you, please. Pete.
Oh, no, not constitutional convention again.
That's a no from Pete. Mick.
Yeah, no, listen, absolutely. I think there has to be a constitutional convention to determine what the function and purpose of the UK is, and whether the nations want to buy into that or not. And that is the ultimate longer term solution.
Akash, and then I'll come to you, Karen, last.
I think it does increasingly feel that, Brexit we're going to look back at Brexit as a sort of critical juncture in the development of the UK constitution. Who knows which way it will go, but I think there are these big questions about the future of the union that one way or the other are going to need to be grappled with. Whether a big constitutional convention is necessarily the right model, I'm open-minded about that, but as I say, I think there's things you can do in the short term, but yes, certainly have the bigger debate about how and whether this whole thing is going to hang together or not.
Karen, would you like
I'm going to take the coward's way out of this and say I'm not going to prejudge the evidence we're going to receive or the findings of the inquiry that we're working on, but I think you know, there is, what's clear from this last hour is there are far more questions being raised than we have answers to at the moment. And what we want to look at for the Procedure Committee in a probably very limited way is just how we can address some of these questions in a positive and constructive way to get some solutions in the short term.
Thanks, Karen, and thank you to all our panelists. I think that's been a really fascinating discussion. Really kind of you to come along and discuss our new report, and thank you to everyone who's been watching. And a final thank you to the Joseph Rowntree Reform Trust for sponsoring this event today. Many thanks.